So I will be introducing our guest today, who is our incredible, brilliant attorney from the legal team for the Uhuru 3, Leonard Goodman, joining us from Chicago, Illinois. And I want to start off by saluting this incredible team of lawyers that came together under the leadership of Hands Off Uhuru, under the leadership of Chairman Amalia Shatella, that included Mutaki Akbar, Addie Griffin, Tom Inskeep, Leonard Goodman, and Angela Rainey. And in particular, I want to shout out Leonard, who we're going to be talking to in just a bit, who took on this case from day one pro bono. And I'm going to be asking him a little bit about why he felt it was important to do that and why he continues to do that. Leonard Goodman also hired for the trial Angela Rainey, who proved to be an absolutely indispensable part of the Hands Off Uhuru, the Uhuru 3 legal team. And Angela Rainey has since started her own private practice and has agreed to stay on the case pro bono herself. So this is an incredible stand taken by these attorneys. Very inspirational stand that they've taken. So as Chair Mwezi and Chairwoman Penny pointed out and announced, the precedent-setting Uhuru 3 appeal hearing is set for Wednesday, July 22nd, 2026, 9 a.m. in courtroom 339 at the Elbert Tuttle U.S. Court of Appeals building in the 11th Circuit Court of Appeals in Atlanta, Georgia. This comes just a week before the 4-year anniversary of the FBI raids on the Uhuru movement. And every single step of this process, we're going to be talking about legal precedents, but as Chairman Amalia Shatella has always helped us understand, the real precedent that has been set with this fight back is in the fight back itself. The political precedent that the chairman created the moment that he stood on the steps of his home on July 29th, 2022, and launched the fight back that has secured every victory since, has proven that when we fight, we win. And this appeal hearing is a continuation of that reality. The hearing is not a given. Getting an oral argument hearing is not a given in an appeal. And the fact that this hearing is happening is once again evidence that the chairman and the Uhuru movement have beaten the odds and shown that you can push back the colonial state. Just doing a little bit of cursory research, I was able to find that the U.S. Court of Appeals for the 11th Circuit grants oral argument hearings only about 11% to 14% of the time. So this is not the norm. This is actually one of the federal appeals courts with the lowest rate of granting oral arguments in the country, with 86 to 89% of cases being decided based solely on the written briefs and the record, and with the vast majority of those cases being decided in favor of the lower court's decision. So the Uhuru 3, as we know, faced trial in Tampa in September of 2024 and faced charges of acting as unregistered Russian agents and conspiracy to act as unregistered Russian agents, which carried a maximum penalty of 15 years in federal prison, effectively the threat of a death sentence for Chairman Amalia Shatella, who was the primary target. And the attorneys brilliantly argued and carried out the political legal strategy to prove that everything that the Uhuru 3 and the chairman engaged in was legal speech protected by the U.S. Constitution's First Amendment and the Bill of Rights, and which ultimately even the judge had to admit on the record. And it wasn't just any speech. It was speech consistent with more than 50 years of leadership and work by the chairman and the party, reparations speech, speech against genocide, speech for the liberation of Africa and African people, and yes, speech in opposition to the U.S. proxy war against Russia, consistent with, as the attorneys showed through 50 years of Burning Spear newspapers, the fact that the chairman has opposed every single U.S. imperialist and U.S. proxy war that has taken place since the inception of the party and even before the inception of the party. So the chairman famously condemned this prosecution as a political attack. He said it was the canary in the coal mine, opening the door for escalated attacks on free speech rights for everyone. That has proven to be the case. The trial ended with a split verdict. The Uhuru 3 were acquitted of the main charge of acting as unregistered Russian agents, And that was a tremendous political victory. As the chairman said on the steps of the courthouse that day, the government could not convict the Uhuru movement of working for anyone except for Black people. And the jury rejected the government's attempt to delegitimize the agency of African people by attributing the voice of African people to Russian propaganda and disinformation, quote unquote. But due to a lot of the issues laid out in our appeal that attorney Leonard Goodman is going to talk to us about, including confusing, misleading jury instructions and prosecutorial misconduct and lies, the jury came to a split verdict convicting the Uhuru Three of conspiracy to do the thing that they found the Uhuru Three not guilty of actually doing. So, by the way, I have done some research and asked actually lawyers and people in our legal support committee to look into if there's ever been a case where someone goes to trial and gets convicted of conspiracy to act as an agent without notifying the attorney general's office, but is acquitted by the same jury of acting as an unregistered agent. No one's been able to find anything. This is actually unprecedented, the way this case turned out. So the conviction has been widely denounced. And the sentencing in December 2024, the prosecutors begged for prison time and massive fines. The judge sentenced the Uhuru Three to 3 years of probation, 300 hours of community service, which he said the Uhuru Three would do standing on our heads. So we did that, and the judge ended the probation 2 years early this past January. And one quick update to give you. Meanwhile, back in the U.S. Attorney's Office in the Middle District of Florida, things are not going quite so well. Daniel Marcet, who you may remember from the trial, is no longer employed by the U.S. Attorney's Office. And we recently learned that he's been replaced by a federal prosecutor named Joseph Ruddy. I'm sorry, I don't think we have a photo of him. Maybe we could get one and pull up, or you can just literally just go to Google and search Joseph Ruddy, federal prosecutor. And the first thing you will see is his mugshot, him wearing an orange jumpsuit after he was arrested for DUI, hit and run, drunk driving. There's body cam footage of him urinating on himself while he was being arrested. He was never charged, and he still works for the prosecutor's office. This is the guy they have now assigned. There he is. There's the prosecutor who is now attached to the Uhuru Three case on the local level. So he will not be the one arguing the case in Atlanta for the government. That will be a DC-based federal appellate attorney named Joseph Minta. And on him, the little we know about him, he did argue a foreign agent case in the appeals court a few years ago. And guess what? He lost. So on the other hand, we have an amazing team that's getting ready for this hearing. Attorney Leonard Goodman will actually be the one presenting the arguments at the appeal hearing, the oral argument hearing, and all of the other attorneys will be present to work with him and to prepare with him and the Uhuru Three during that hearing. So I want to end this introduction by quoting the attorney that we're about to hear from, Leonard Goodman, who said, "The government here is using this foreign agents law to prosecute members of an activist group for political speech and activism in opposition to U.S. foreign policy. In so doing, this prosecution strikes at the heart of the First Amendment." So we just want to welcome and salute the incredible attorney, Leonard Goodman. Uhuru.
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 Uhuru. Uhuru. Good to see you as always.
Oh, it's great to see you all.
Yes, yes. So first question is to just talk about what it means that this appeal brief that you did so much incredible work on, and our other great attorneys as well. What does it mean that the appeal brief was granted oral arguments, and what can people expect who will be coming to Atlanta on July 22nd?
Well, thank you, Jesse. Yeah, first of all, you gave me some news. I was not aware that only such a small percentage of 11th Circuit cases were granted oral arguments. So thanks for that news. I also wasn't aware that you all had broken the prosecutor's office in the Middle District of Florida. So congratulations for that. So we'll have oral arguments. I guess they're rarely granted down in Atlanta. We got one, so they clearly think that our appeal has legs, and they want to hear from the lawyers. They want the government to defend their prosecution. They want to hear our position as to why this needs to be reversed. And we have 15 minutes to make that case. The government will also have 15 minutes to make their case. It's very hard to predict how these things will go. We have basically three issues on appeal. One is that this case should never have been allowed to go to trial because, as you mentioned, it targets political speech. And as Jesse told you, the judge actually came around to this view. It took a while, but at the sentencing hearing, he said, yes, this case was just about political speech. I wish he had come around to that a little earlier. It might have changed this. But really, the argument is you should never have had to stand trial for political speech. And I think we all know why they were targeted. Lots of people make political speech, lots of groups that have followers the way the chairman does and Jesse and Penny do that have followers make political speeches. So why was yours so threatening? Well, I think if you remember what was happening in July of 2022, the U.S. government was trying to convince Congress to fund a proxy war against Russia. And at that time, the chairman, Jesse and Penny, were espousing views that were pro-Russia. And that can't be had at that time. It was considered dangerous. And so we can't allow that. We can't allow the government to say, yeah, there's free speech, but not when we don't like it or when it harms our political agenda. So that's why this case is so important. And that's why I think this appeal is so important. As Jesse said, all of you have already completed your probation. So it's not about you all facing jail or anything like that. It's about precedent. Because if they can do this to these three, the Uhuru three, they can do it to anyone that has political speech, that has followers, that has people listening to them, where that speech is inconvenient to the government's political agenda and especially their imperialist agenda.
Yes.
So we have three issues. So the first issue is it should never have been brought. The second issue is, well, there's no evidence. They didn't present any evidence that you all were agents of Russia, which an agent under the law, it means you're under the direction and control of Russia. No, there was no such evidence. Now, normally that's a losing issue to say there's no evidence after a jury comes back with a finding. But in this case, it's very unusual. First of all, they had no witnesses at trial that pointed a finger and said, I saw this guy, these people act as agents, or I saw them do something illegal. Not one person. They've been around South Florida, Tampa, St. Petersburg area for 50 years. Not one person could they find that could say a bad word about them. So it was a paper case, documents that they pulled off the web of their communications with Russian national. And then they called 4 agents to go through these documents and explain them to the jury and explain their significance. Every single one of those 4 agents said there was no evidence that they were under direction and control. They were pursuing their own agenda, and they were not pursuing Russia's agenda. And they they would join with Russia on certain issues that furthered their core values. So that should be the end of the matter, really. There is no evidence. They've admitted it. The government really has no answer to any of these. You know, they bring up the argument of national security, which is sort of the last refuge of scoundrels. Well, we're doing this for national security. And the one thing I think people need to keep in mind, and I think it's wonderful for people to come down to Atlanta and show support, but it's very important for people to be respectful of the court because we don't want to give any fuel to this bogus argument that this is somehow a national security case. You can look at the indictment. The court can look at the indictment. There's nothing in there about national security. What the indictment says is you all are guilty of spreading pro-Russian speech, which they call propaganda and misinformation. Although, as we showed at trial, there was no misinformation. Everything that you said was truthful. Everything that O'Malley said was truthful about the support of Ukraine, about the coup in 2014, about NATO's encroachment towards Russia's borders. It was all truthful. But, you know, that doesn't matter to the government because it was inconvenient and they didn't want you making those truthful points. So that's the second argument. The third argument is, well, how do you convict somebody of a crime with no evidence? Well, you mislead the jury. And so that's our third argument. It's probably the least important argument because it would only get us a new trial. The other two would be a complete win, a vindication, an exoneration. A new trial will still take as a door prize, but and win the case at a retrial. But so those are our three arguments, and we'll have 15 minutes to present it. Now, when you have 15 minutes, the judges are going to let you know what they're interested in and what they're concerned about. So the point for us and these other great lawyers that I've been working with, and I've been so proud to get to know, Mutaki and Adi especially, and also Angela and Tom. So what we have to do is prepare for whatever the judge. It's hard to predict what the judges are going to be concerned about, but we have to be prepared to answer their questions and satisfy their concerns about our position.
Excellent. That was great. Thank you so much, Attorney Leonard Goodman. That was, I mean, you answered most of my questions just now, so thank you so much. And I know we don't know who the three judges will be yet. I think that was like maybe July 7th, we heard was when those names will be announced. So that will be interesting to see. And I guess kind of the final question here is: you took this case on. You were there from the beginning in terms of this legal team coming together. You came on pro bono. You've stayed on as such ever since, every step of the way. What has this case meant to you, and why has it been so important to you for you to be a part of this?
Well, I believe in free speech. I'm, maybe a free speech absolutist. And this is an incredibly dangerous case to say that we're going to prosecute you under federal criminal law, make you face long prison sentences if convicted. And we're going to do that because we don't like the contents of your political speech. Now, I had known of Chairman Yeshitela's work throughout the years, and I happen to agree with his anti-colonialist views, but that really wasn't the reason why. I believe in what the Supreme Court has said for 100 years is that the cure for bad speech, if you think somebody is saying something wrong, the cure for that is more speech. Correct them. Go out there and give your own speech. Write your own articles. Write your own op-eds. It's not to censor. It's not to prosecute people for speech that we don't like. And if this precedent is followed, if the courts allow this type of case, we're all in danger.
Uhuru. Thank you so much, Attorney Goodman. It's been an honor to have you on, and we're very proud to be represented by you as well as our other incredible lawyers. And we'll see you in Atlanta.
Okay. Thank you all.
Uhuru.
Uhuru.